CPL Test 9, CPL 722. Question 1. CPL 722.00. Which, if any, of the following are correct statements regarding the youth part? And it's 1. All juvenile offenders and adolescent offenders shall be notified of the availability of services through the local probation department. 2. Services through the local probation department shall include the ability of the probation department to conduct a risk and needs assessment utilizing a validated risk assessment tool in order to help determine suitable and individualized programming and referrals. Assessment voluntary. 4. Based upon assessment findings, the probation department shall refer the juvenile or adolescent offender to available and appropriate services. 5. The probation service shall not transmit or communicate to the district attorney or youth part any statement made by a juvenile or adolescent offender to a probation officer. 2. 722.10. Which of the following are true regarding the youth part of the Superior Court? And it's all of the above. 1. Judges of the youth part shall be family court judges as described in Article 6, Section 1 of the Constitution. 2. The youth part shall have exclusive jurisdiction in all proceedings in relation to juvenile and adolescent offenders except as provided in this article or CPL 725, which is removal to family court. And 3. The presiding justice of each appellate division is responsible for designating judges who are authorized by law to exercise criminal jurisdiction to serve as accessible magistrates for the purpose of acting in place of the youth part for certain first appearance proceedings involving youths as provided by law. 3. CPL 722 and 1.2041 and 1.2042 select the false statement. Oh, so 12041 is, those are definitions of juvenile offender, and 44 I thought was adolescent offender. But, okay. I think 42 is juvenile offender and 44 is adolescent offender. The one that is wrong, which I was a little confused on, is, no, not this one. I was confused on B. Okay. A is wrong. Tommy is 16 years of age when he is arrested on December 5th. It is alleged that he committed a sexual motivated felony on September 20th. When he was 16 years of age, Tommy must be arraigned in the youth part of the Superior Court. That is false. That is false. It is not true. He would not go to the youth part because someone is an adolescent offender at the time the crime was committed. Not the date of arraignment, not the date of arrest, the date that the alleged crime occurred. B. Chris is 15 years old when he is arrested and charged with robbery in the second degree, a violent felony offense allegedly committed on September 30th when he was 15 years old. Chris must be arraigned in the youth part of the Superior Court, and if such part is not in session, before the most accessible magistrate. The youth part has exclusive jurisdiction over his case. That is true, because Chris is 15 years old, having committed a felony for which one that a 15-year-old would be designated a juvenile offender. He is a juvenile offender, so even September 30th, it doesn't matter if he was, it's only the 16-year-olds, the adolescent offender, that is effective October 1st, 2018, and that's what I got confused with. Those, the 15 years old threw me off. Okay. C, Mary is 17 years old when she is arrested on December 22nd for an armed felony allegedly committed on October 17th, 2018, when she was 16 years old. Mary is an adolescent offender. That is true. Again, because the crime of the crime was committed on October 17th, which was after October 1st. So again, it does not matter when she was arrested, it's the date that the crime was commenced. And D, Barbara is 13 years old when she is arrested and charged with an act which, if committed by an adult, would constitute the crime of murder in the second degree, allegedly committed when she was 12 years old. Barbara cannot be arraigned in the youth part of the Superior Court. That is true, because a 13-year-old is a juvenile offender if they commit murder in the second degree. A 12-year-old is not. So that would go to family court, and she would be a juvenile delinquent. 4. True or false? Jackie, Arlene, and Lori are all 16 years old when they are arrested on October 30th, 2018. It is alleged that they acted in concert with each other and committed various felonies relating to credit card thefts between October 3rd and October 20th. When they were all 16 years old, Jackie, Arlene, and Lori must be arraigned in the youth part of the Superior Court, or if such part is not in session, before the most accessible magistrate, and such youth part has exclusive jurisdiction over their cases. That is true. They were all 16. That is, and it says various felonies. It has to be a felony, and that would go to the youth part. It was after October 1st, so they're all going to the youth part. 5. 72210. The presiding justice of the appellate division designates judges to act in the event the youth part is not in session. 6. If after arraignment there is reasonable cause to believe that an adolescent offender committed a felony, the youth part of the Superior Court must order D, that the defendant be held for the action of the grand jury. And that was from 72221. Again, 72221. If after arraignment there is reasonable cause to believe that an adolescent offender committed a felony, the youth part of the Superior Court must order that the defendant be held for the action of the grand jury. And I believe that this is also like a felony case of one in section 180 of the CPL, where the time would also be relevant here, but it doesn't say anything about that in 722. But if they're being held for the action of the grand jury, I would believe that it would be the same conditions, where they would have to be released if they weren't indicted, right? I'm gonna have to go look into that. Okay, so going back to what I was saying before, 722 applies in lieu of Article CPL 18030, 18050, and 18070. Those were all repealed. However, 18080 times still applies to the youth part. So it's not only on a felony complaint for adults, but also on juvenile offenders or adolescent offenders who are being arraigned on a felony complaint, because as we know, you cannot prosecute on a felony complaint. So if somebody is confined in custody for more than 120 hours and they are a juvenile offender or an adolescent offender, or they're confined in custody for more than 144 hours if they're in the event of a Saturday, Sunday, or legal holiday, they must be released if there is no disposition or hearing on the felony complaint. And we know that a disposition has to be like either they're indicted or there's a Superior Court information filed, because they cannot be prosecuted on a felony complaint. So again, if somebody is taken in custody on a felony complaint of a juvenile offender or a youthful offender, 180 times still applies, and that means if somebody is held in custody on a felony complaint for more than 120 hours, or in the event of a Saturday, Sunday, or legal holiday, 144 hours, they must be released if there's no disposition or hearing on the felony complaints.